I think we have been invited to this panel discussion because we are a member of both the Consultative Forum of Frontex and of EASO for the time being. And I will not so much go into the kind of legal, technical debate about, the whole the setup of the two agencies, or the upcoming new agency in the case of the EU Asylum Agency. I will more look at it from the perspective of what are these new steering and monitoring functions that Lilian has described, particularly also from the perspective of the EU Asylum Agency. How can it actually impact, indeed, the fundamental rights of asylum seekers, and how can this actually also start to shape asylum policies? On the one hand, on the side of the EU Asylum Agency, I will then say a few words about the effectiveness or lack of effectiveness of monitoring tools at the disposal of the agencies, and there I will mostly look at what we see in the context of Frontex. But of course, obviously, from the perspective of monitoring in terms of the agency's task to ensure and guarantee the protection of fundamental rights in all its activities. So I will not look at that other function of the monitoring mechanisms within Frontex, which is indeed also about assessing technical capacity for controlling the borders and so on and so on. I guess Richard will dwell on that. And then I will conclude with a few words about the actual sanctions that are possible under the two mandates, or the upcoming mandates of the EU Asylum Agency and the current mandate of Frontex, with regards to suspension and termination of operations because of persistent human rights violations. A first point I wanted to make is what Lilian has already mentioned with regards to the role of the EU Asylum Agency under the new mandate. Again, we're talking here in the assumption that what is on the table will be adopted, but nobody knows that, of course. But that's the assumption that I make. And I wanted to point at this particular issue, this new instrument that indeed has been watered down, but which I think could still has the potential of effectively steering to a large extent or to an important degree the actual asylum practices of the member states, and that is indeed that possibility of the EU Asylum Agency to issue country guidance notes on the basis of common analysis of the country of origin situation with regards to specific countries. What it will exactly look like is not very much described in the compromise as we know it. It simply says that that these guidance notes can be issued with regards to specific countries of origin to assist member states in assessing applications from those countries. Now, you could imagine all kinds of things around that, and maybe Francois and others will maybe be able to inform us a bit more about what the thinking is about what this actually could mean. But of course, in the perspective of the objective of the agency to contribute to more convergence of decision-making, which is one of the key objectives in this new mandate, one could imagine that it would indeed, if not giving instructions to member states, at least give indications as to how asylum applications from a particular country should be treated. And we could imagine that it would look at specific profiles of people and give indications as to whether or not these people should be granted international protection or not. Again, this is not very clear as this is what it means under the directive, but this is what it could mean. And I think from a purely harmonization perspective, that makes perfect sense. This is what you want to do. You can't stay just at the level of what Lilian has described as we know it now. EASO collects country of origin information, discusses it with the COI networks, makes it available to the member states, and so on and so on. We've seen that that has not resulted in more convergence of decision-making. Simon Mordew this morning has quoted the still persistent problem of the diverging recognition rates. And therefore, of course, you need to have some guidance, some instructions to member states as to how, or try to steer how then this information is actually being used in the application of, in the assessment of asylum applications. It is important to know that these guidance notes have to be endorsed by the management board. And as Lilian says, of course, the management board consists of representatives of all the member states, Commission is present, and UNHCR, but UNHCR has no voting rights. I think from the perspective of protection, it raises a number of questions, and in particular, the fact that endorsement by the member state, by the management board of these guidance notes, or non-endorsement of these guidance notes, might not only be on the basis of purely protection considerations. It might be on the basis of other policy considerations, administrative convenience, and then in particular in the context of a common European asylum system that is more and more evolving towards a system that is based on presumptions of safety through the use of safe country of origin concepts, safe third country concepts, and so on and so on. I don't think that this is just that potential effect would be just theoretical. I think it is a real danger. That is also, of course, because, and again, people from EASO might disagree with me, but the agency as such has not a protection mandate. It is not the European UNHCR. It is there to support member states, to contribute to the proper implementation of the common European asylum system, the acquis that has been decided elsewhere by the institutions, but as such it has no power, it has no competence to grant protection, of course, because it doesn't have the powers to take individual decisions on applicants. And therefore, I think this kind of tension is problematic, I think, in the development of the agency, and also because, of course, the executive director, because these guidance notes have to be endorsed by the management board, will probably become under a lot of pressure from the member states to go in one or the other direction as to what these guidance notes would say. Another issue with regards to these guidance notes, and it's more at a different level, but is the fact, of course, that we have already a specialized organization, a global organization, who issues eligibility guidelines. It's UNHCR. And creating this possibility of giving guidance notes risks distorting this very important function of UNHCR as a supervisory authority for the correct implementation of the Geneva Convention. So there is also potential danger that these guidance notes might actually undermine the authority of UNHCR eligibility guidelines. And then, of course, this is to a certain extent acknowledged in the compromise. It says that the agency should take note of, it doesn't even say take into account, it should take note of the most recent UNHCR eligibility guidelines. But it doesn't say what should happen if there is a difference of opinion between the agency and the UNHCR. So there, I think that is a potential problem. This issue of the influence that the management board can have in actually steering what the actual guidance or instruction is going to be. Is of course pointing at a more fundamental problem in terms of conferring more and more powers in the asylum field to an agency, and the kind of the actual governance structure of the agency in that regard is problematic from a protection perspective. And I'm saying that also in terms of the recurring debates about creating an EU asylum authority with competence to take individual decisions, which probably, if you really want to establish a common European asylum system, is probably the only way to do away with the current disparities in the practices. But in my view, at least, it would be very problematic to do that under the form of an agency because of these reasons that I give you. The problem is what would be another form, what would be another body that could take up that role if you don't entrust that function to the agency. A second remark is about the monitoring function of the EU Asylum Agency. Is it 1 minute? Okay, sorry. So I've just had one point. So then I'll just say 2 words about the monitoring function of the EU Asylum Agency. There, to be honest, I mean, I can't really understand what the wording means. The monitoring of the technical and operational application of the Common European Asylum System. It's clear, we understand, it couldn't clearly say we are going to monitor the implementation of the Common European, of the EU Asylum Acquis, because of course that would be stepping into the field where the competences of the Commission. But frankly speaking, you know, I can't see how they cannot do that. If they want to assess the monitoring of the technical and operational application of the Common European Asylum System, they will have to look at how EU asylum law is being applied. And there are just 2 remarks. I think it's very important that the scope of that monitoring exercise, if this is to have any added value, needs to be complete, it needs to be comprehensive, and there is the potential for that. The regulation says that all aspects of the Common European Asylum System should be monitored by that mechanism. But it then specifies particular aspects, and 2 important elements are not mentioned. One is detention, the other one is legal assistance. These are 2 very important aspects now of the acquis of the Common European Asylum System, and I think it would be very important to have a look at that, because we do see, in particular in detention, increasing use of that system. And a last point is, of course, and then I will conclude, you will forgive me about the self-promotion aspect of my remark, but I do think it is important, is that this monitoring exercise, of course, by EASO should, of course, take into account all sources and all expertise. The way this is being presented in the compromise is that it's primarily will be based on information provided by the member states. It does make reference to the fact that also other sources, UNHCR, international governmental organizations, and other relevant organizations are mentioned. Note the fact that the EU co-legislature is actually allergic to referring explicitly to non-governmental organizations, but of course relevant organizations, that's what it should read. And I think there is a wealth of information there with NGOs that the monitoring system should tap into. I'm very sorry, I had a lot of other remarks on Frontex, but maybe I can make those in the discussion.